Uma garu, can we start అండి?
Sorry.
Yeah.
If you want to, you can, or if you want to give a few minutes.
We can
I'm okay
give
with
few more minutes then, 5 or 6 minutes, 5
Sure.
minutes then maybe.
Sure.
Okay, Uma garu, we can start అండి.
Sure.
So I'll give small introduction and then hand over to you, Uma garu. So on October 1st, we did TCA in collaboration with Sneha Hastam along with Mantra Law Office presented a webinar for latest immigration updates from October Visa Bulletin on EB1, EB2, and EB3 green card date updates. Due to huge turnaround on last call, we could not cover all the questions. So this is the follow-up session for last week's. Yeah, you can start, Magaru.
Hi, good evening, and thank you once again to Houston TCA, the entire executive board, Sirisha, Geeta Garu, Indira, and others from Sneha Hastam. Sorry, I've been talking the whole day, so my throat is a little bad today. Thank you to each one of you for, for all your efforts to bring these webinars to the community. And I am sure a lot of them are benefiting from it. And we are continuing to do this for the benefit of the community. So thank you all, and those of you who could join us today on a Friday evening. I'm just going to go through the run through of what we are doing, what this great mad rush is for downgrading from an EB2 to an EB3. Most of you know what is an EB2. It is an employment-based category 2 with people with advanced degrees, either a master or bachelor's with prior 5 years of progressive experience. And EB3 is somebody with a bachelor's degree only. So those are the categories, and the October 2020 Visa Bulletin has created a frenzy among all the people from the Indian community particularly, and also some from the Chinese country. And so these are the two countries which are mainly looking at, do we downgrade from an EB2 to an EB3? What is the October Visa Bulletin? What are the predictions for the future? How do we anticipate the movements of the Visa Bulletin coming in November and December? Do we know about it, or can we make an educated guess about it? These are the things we're going to talk about. And should the EB2 to EB3, should it be an amendment, or should it be a new I-140 filing? That has been the greatest confusion for every one of you. So we're going to focus a little bit more on that part of it, but I'm just going to go through the agenda for today's webinar. So if we can go to the next slide, please. I brought this little, can we go to the previous? Yes, thank you. I brought this, I put this little, kind of a quote saying, when opportunity knocks on your door, always be willing to take a chance, because you never know how perfect something can turn out to be. And this is exactly what can happen with this Visa Bulletin. And because a lot of people are still wondering, do I not? Because they call me at my office and I hear them saying, I'm going to go forward today. And then the next morning it's going to be, I'm not going to go forward. And then the following morning it's again, I think I'm going to go forward. So there's a great amount of confusion among everybody in the community. And hopefully this webinar will try to bring a closure for all of you. So that's what we're talking about today. The most important 2 or 3 topics that is going to focus on is, do I file an amended, or do I file a new I-140? What are the strategies? What are the pros? What are the cons? Those are the things we're going to talk about. And I'm also going to come and touch a little bit about the new H-1B visa regulations, the interim final rule that was published in the Federal Register just a couple of days ago. And I'm just going to touch about it, but mainly today we're going to focus on the October 2020 Visa Bulletin and the pros and cons of EB2 to EB3, and should I be filing a new or an amended? So these are the things. Let's go to the next slide, please. That was the agenda that I just talked about, and the October 2020 Visa Bulletin, which most of you know. There are 2 kinds of charts. One is the final action date, and one is the dates of filing. And the October 2020 visa bulletin, they came and started with saying that they would accept the final the dates of filing. Then the USCIS went back and said no. Then they came back finally and said, yes, we are going to accept the dates of filing. And believe me, I have seen this very few times in all my years of practice. Once it was in 1996, 97. Then it came about in 2000, then 2007, and then 2012. This is for India, I'm talking. And 2018, the Chinese people had the similar kind of situation, and a lot of people had opted with the downgrading from EB2 to EB3. So I don't know how many times this is going to come about. I don't know if the November bulletin, we will see that, or we may not see it. So let's go to the next slide, please. The predictions. Typically, when we see a visa bulletin, they tell us that the minimum family-sponsored preference limit is about 226. That is the world level for all the family-sponsored. Then the world level for the annual employment base immigrants is about 140,000, out of which they set a per country limit of about 7%. That may be about 25,620. So, but for this particular visa bulletin for October 2020, we were going to see an additional spike of close to 261,500, for the reason being, one, the fiscal year was starting October 1st. Secondly, there were a lot of family-based adjustment of status, and also consular processing that was not processed as much as it should have been. So the demand for the family-based dropped down. So based on which there were a number of visas that were available, and the government, the Trump administration, had said that they would use some of these visas and bleed them into the employment base, which could create more number of applications that they can accept, and which is the reason why they went with the dates of filing as opposed to the final action dates, which is why it's giving you this golden opportunity to go ahead and file your applications in the October visa bulletin. We'll go to the next slide, please. And we're talking about the dates of filing versus the final action dates. Everybody knows the difference, but I still wanted to create this little table to show you with the date. If you go with the date of filing, for example, for India, the date of filing for EB2 is somewhere in 2009, and for EB3, it's 2010. So how would that work for somebody whose final dates of action is current? They will, if they are just filing their I-140, the I-140 will be processed both with the dates of filing as well as the final action dates. And if you concurrently file for your I-485, both in the dates of filing as well as the final action dates, your 485 will be pending, and you will be issued an EAD and an advance parole. And if your I-140 is already approved, and your adjustment of status under the dates of filing will only be pending because they cannot actually process it, adjudicate it, and give you a green card because there is no visa available. They're only accepting the applications based on the date of filing. However, the 180-day rule becomes eligible both in the dates of filing as well as in the final action date. So I just wanted to show you the chart so you can see how to compare this, and it might help you with that. Let's move on to the next chart, the next slide, please. And I wanted to, again, explain the strategies of whether one should amend or you should be filing a new I-140, and what are the strategic issues, and how do you base the authority? Can you amend, or can you file a new I-140? There is a memo that was issued by Mr. Newfield way back in 2007 when the 2007 visa bulletin came out. And based on that, he clearly said that you could amend the I-140 if you choose to, and downgrade it to an EB3, because back then that's what was available. And that's how it was done based on the Newfield memo in 2007. However, right now, when we come and look at how do we process it in 2020, the Newfield memo still allows, if you want to file a new I-140 instead of amending it, based on Section 8 CFR 205.E, you can file a new petition, and I will tell you what are the pros and cons of both of it as we progress a little bit. So you could do an amendment if you choose to, and you can also file a new I-140. So if we file an EB3 downgrade, and if it is approved, if you file it as an amendment as opposed to a new I-140, your EB2 will no longer exist. And if you file it as a new I-140, the EB2 is not affected. It continues to remain, meaning you'll have the EB3 I-140 as well as the EB2 I-140 both in place, and it's not going to be affected. But if you file it as an amendment, basically, when you use the word amendment, you're telling them, I am now changing what I did previously. I'm amending that and coming into a different classification. So by using the word amendment, you're clearly telling them that you don't I-140 under the EB2. So you may not want to do that. You may want to have both of them, both the EB3 as well as the EB2, because if the EB2 in the future starts moving better and you want to go back to that, can you do that? Yes, you can. We'll come and discuss that. It's called as interfiling, and you can go back to the EB2 line. So it was not approved. So logically, nothing happened to the EB2. The EB2 remains intact. But when you file a new I-140, the same effect is there. The EB2 is not affected, whether it's approved or whether it's denied. In both cases, you have the advantage. And there's something called as the Child Status Protection Act. The reason I put that there is there are a lot of parents who have children and who are going to be reaching the age of 21 sooner or later, and they're worried about that. So if you file a downgrade of an EB2 to an EB3, can you take advantage of the CSPA if you're amending the petition versus if you're filing a new I-140? Now, if you file as an amendment, you may not be able to take advantage of the CSPA, but whereas if you file it as a new I-140 petition, you're eligible, or your child is eligible for the CSPA protection. Now, if there's a retrogression, and I know many of you have this question even from last time, what happens if the EB3 line now gets longer and the government decides that there were too many applicants in this October visa bulletin who have filed? So we'll have to retrogress the dates, pull them backwards. So if that happens, what happens to your petition if you were to have filed it as an amendment? And if you do that as an amendment, what happens is you lose your spot. You'll have to go back because it was no longer existing. Once you filed it as an amendment and it's gone due to retrogression, you have to go back, amend it, and refile a new EB2 perm and an I-140. So whereas if you are filing a new I-140, as I mentioned, the EB2 is not affected, whether it's approved or whether it's denied. So what happens is when you have the retrogression and you see that the EB2 line is heading faster as opposed to the EB3 line, and you want to go back to the EB2, you can always do what's known as an interfiling because you've maintained both the EB2 as well as the EB3. So now since you have both of them intact, you can go back and notify the USCIS that you'd like to continue with the adjustment of status as an interfile and use it toward against your EB2 priority date. And since your EB2 PERM and I-140 have been approved, now you want to continue it as an EB2 filing, which is known as the interfiling, but it's not an automatic thing. Your attorney, your employer's attorney, will have to write a letter to the USCIS that they now wish to interfile it as an EB2 and continue the adjustment of status as an EB2. There has been some discussion, even in AILA. Some attorneys have come and said that it may not be that you can just start where you left off with the EB3 filing, which is the adjustment of status. You may have to forego the adjustment of status application and have to refile another 485. So there is no clarity on that issue, whether you're going to interfile it using a new I-485, or if you're just going to be able to continue with the 485 that you already filed. So on that, I don't have a clarity on it. So I'm not able to tell you with a conviction whether you can just continue with the existing 485 or you'll have to file another 485. However, having said that, if there is the option that you can withdraw the 485 under the EB3 and file another 485 under the EB2 still as an interfiling. But there is one other issue that I wanted to bring it up, which we discussed last time too. Now, once you downgrade and file as an EB3, and if you avail the benefits of an EB3, which is using the EAD or an advanced parole, then you're going to have issues to come back to the EB2, and that is going to be a lengthy discussion. I won't be able to discuss the whole thing here, but it is going to be a lengthy issue for you if you've used the benefits under the EB3. And like I said, mentioned it last time itself, you cannot have the cake and eat it too, which means you can only, if you avail the benefits of EB3, now you need to remain in that category. Coming back to EB2, you may be able to do it. AILA has given us instructions. If somebody does that, they'll have to come back and file another PERM and an I-140, and then come back into possibly recapturing the priority date. But they'll have to go through that process in order to come back into the EB2 line if they have availed the benefits under the EB3 downgrading. Can we go to the next slide, please? Continuing EB2 to EB3, do you amend versus file a new I-140? And as I mentioned, there is a lot of support from the USCIS adjudicators that they do support an amended petition based on what happened in 1996, 97, 2007, and 2012. But we as members of AILA attorneys, there's been a high recommendation and a historic practice by all the attorneys, and they recommend that we don't file it as an amendment, rather you file it as a new I-140, and that way you're not losing out your chance on the EB2. By downgrading, both EB2 and EB3 are preserved, whereas if you file it as an amendment, the approved EB2 no longer exists when you file it as an amendment. So historically, and with all the case law that we have seen in the last 20 days, we've been doing a lot of reading. And also I have worked with a lot of people back in 2007 and 2012. We definitely went with filing the new I-140s. We didn't have a problem back then. The administration was receptive to accepting cases as a new I-140 versus an amended I-140. So I would highly recommend to all of you to speak to your employers and to the employers' attorneys that it is a better practice to go ahead and file it as a new I-140 rather than as an amended I-140. Because if you file it as an amendment and if the EB-3 is denied, you may be given the permission to file a new EB-2 permanent I-140, but then since the EB-2 is no longer there, you lose that much of time to come back into the line again. And there's a lot of time, money, and we don't know what will be the regulations by then, especially now that USCIS is coming up with the prevailing wage rule that is increasing the salary. So you'll have to go through all of that. To avoid that, the best thing would be to file it as a new I-140 as opposed to an amended I-140. Can go to the next slide, please. And when you're filing this as a new I-140, you still, as an employer, employee, or a petitioner, employee, petitioner, beneficiary, you have to make sure that you provide all the supporting documents, which is including a copy of the approved certified perm, a copy of your approved I-140 under the EB-2, and you also have to provide all the supporting documents to show that your employer has the ability to pay, which includes the employer's tax documents, the employee's degrees, transcripts, experience letters, all of those documents. You cannot assume that since you had a previous 140 approved that the government is just going to automatically approve this. And as I mentioned last time, there will be no premium processing for a new I-140 because your perm was already used for your EB-2 filing. So you're now going to only be able to submit a copy of your perm. And when you do that, the government does not allow you to use a premium processing. So like I mentioned in the last webinar, the best thing would be to file it as a regular and give the government a month or two so that they can secure the original perm from the file. And then you can request them to then upgrade it to a premium process. So these are some of the things that I wanted to make sure that you all understood. We'll go to the next slide, please. And how do you leverage, this is a big question that people have. I was working with company A. Company A filed my perm I-140, and subsequently I got a great job with IBM. I'm no longer with the employer who petitioned for my perm and I-140. I left them. Now I'm working for IBM. IBM pays a bigger chunk of salary as compared to my employer. So what do you think will happen? Do I have to go back and work for that employer so that the employer can now process my green card, which is filing the downgrade from an EB-2 to an EB-3, and concurrently filing the adjustment of status. Now, you don't have to work for that employer who petitioned for you. However, that employer definitely has to be the one to file your new I-140, reclassifying you from an EB-2 to an EB-3. So you definitely need the petitioner's help and support. So sometimes that employer may say, unless you come and work for me, I'm not going to do it. Now that is a different issue to deal with, but by law, you don't have to work for the petitioning employer until such time you get your green card. Now, once you get a green card, you definitely have to go and work for the petitioner who filed for your perm and I-140. Now, there has to be a bona fide job offer, and you must have the intent to work, otherwise it would be considered a fraud. And the employer or the petitioner still needs to meet the new I-140 filing with the ability to pay. So they have to provide their tax returns, their company documents. So this is something the employer should be willing to give you and willing to support you with that documentation. How do you leverage with them? Either you give them an assurance that you will come and work for them once you get the green card, or at some point in time, you would have to agree to go work for them if that's the only condition they're placing against continuing with this petition. And clearly, without the employer support, you cannot file this on your own, especially if you're doing a downgrade from an EB2 to EB3. You definitely need that I-140 to be filed before anything else can be adjudicated. So let's go to the next slide, please. There was a lot of questions whether you have to file the I-944, which is the public charge issue, or it's also called the self-sufficiency form, which is required. We have noticed, and a lot of AILA attorneys have noticed, even though the government said that if you file it before October the 13th, they would accept the applications, your 485 package, without the 944. But a lot of attorneys have seen kickbacks. Their packages were returned back to them because they did not submit the I-944 along, even though the website of USCIS says they don't need to file it. Still, the filing intake clerks have rejected it. So you need to be extremely, careful to make sure that you submit the I-944 for every individual who's filing a 485. That includes the individual who's the beneficiary of the I-140, his spouse, and even children, even if they are 1 year, 2 years, 5 years, it doesn't matter, they still have to file the 944. And believe me, the 944 is one of the craziest forms I have ever seen in my entire practice. It is lengthy, it is crazy, so don't get frustrated. You still have to give all the documentation, which includes the credit report. Sometimes they ask for your educational documentation. So whatever you can give, please go ahead and submit it along with the 944. So just wanted to bring that up so that everybody is aware that a 944 is to be filed along with your 485 package. I'll leave any questions. I'll open it up, and if somebody has emailed, or I don't know if it's in the chat box, Sirisha or Indra, one of you can take it up and we'll take it. We
don't have any chat questions, Andy. We can open, we'll unmute all and they can ask questions directly one by one.
Sure.
Oops. 1 second, I'm trying to. So they can unmute themselves and start asking questions.
Hi, can you hear me?
Yeah. Hi, Srinivas. Yes, please go ahead.
Thank you for taking the call. Yes, thank you for the detailed presentation. That was pretty clear in terms of the update and amendment. So we talked about an amendment. So if an amendment is denied, the EB2 would be denied. I mean, that would no longer exist if the amendment is denied.
Umagaru, you're muted. Okay, yeah.
All right. If we can go back to the slides, I can show you the slide where I clearly said, if your EB3 downgrade is denied, then your EB2 is alive with an amendment. But if your EB3 downgrade is approved with an amendment, then your EB2 is no longer there. It doesn't exist.
Okay. So EB3 amendment is denied, but still that EB2 will remain unaffected. Okay. Yeah.
Correct. Correct. I mean, if you look at it logically, one is gone, so the other is alive with an amendment. Whereas with a new filing, neither one is affected.
Oh, okay. Got it. Yeah. Thank you for the clarification.
You're welcome.
Yeah. If you all have any questions, please unmute yourself and ask Uma Garu directly, please.
Oh, hi, Uma.
Hi.
I have a question about the scenario where retrogression occurs. So the amendment, I see that we have to amend back and refile. Like, do we have to do both, or if we just amend back, can we request USAIS to point us towards EB2, or like, do we have to amend back and then refile a new EB2 and then a new 140?
Right. If you're filing it as an amendment now, if you're downgrading and filing your I-140 as an amendment, what happens is your EB2 no longer exists. It's gone. The 140 is gone. Okay. Technically, we have been told that the perm, there is no expiration for a perm. It always remains. And especially if the perm was used in conjunction with an I-140 within 180 days, then the perm doesn't die. That is what we've been told. But there is a confusion based on what we have looked at history with the adjudicators. Because you filed it as an amendment and not as a new I-140, your EB2 no longer exists. So they're asking you to refile a new EB2 perm and an I-140. But if you file it as a new I-140, nothing gets affected.
So once we use, thank you for the answer. Once we use the EAD, so and then if retrogression occurs, so we basically have to start all over again, right? There's pretty
well, once you use the benefits of EB3, as I mentioned to you, now you're stuck in that because you can't have the cake and eat it too, because you've used the benefits of EB3. Now, if you have to go back to EB2, our understanding, and there is not a clear cut answer to this, is it is going to be a lengthy process wherein you would have to file your EB2 perm and I-140. You will definitely be able to recapture the date under the current rules, but you'll have to file a perm and I-140.
Okay, thank you. I have one more question about the AC21, probably not related to what you presented today. I heard somewhere about the 180-day clock being reset if we switch employers in the case of interfiling. So could you please elaborate on that?
The AC21 180 days is, for example, if I mentioned it, when you file an I-140 and the I-140 has been approved and you file the adjustment of status concurrently under the dates of filing right now, you have 180 days. After 180 days, the AC21 kicks in and you can port it to a new employer without having to file another I-140 or a perm. You literally take the whole package to the new employer. Whether there's a retrogression or not, whenever the employer chooses to, they can do the portability under AC21. Now, if you have to do the interfiling, you can only do the interfiling if you filed a new I-140. The interfiling is not available if you're filing it as an amendment.
Oh, okay. I have one more question regarding AC21. For example, let's say I'm not allowed premium processing for the 140 at a future point of time. So I understand that we cannot use premium processing initially when we file concurrently. But let's say 180 days have passed since since the 485 is pending, and my 140 gets approved after like 8 or 9 months. So do I have to wait another 180 days to port, or can I just move forward after my 140 gets approved? Once it's beyond
anytime after the 180 days and after the I-140 is approved, you can port it. you don't have to wait another 180 days.
Oh, thank you so much.
But the most important thing is if you're filing as an EB3 downgrade and you're not able to use premium processing at the moment, it may take 4 months, 6 months for the 140 to be approved. So by the time you get to the 180 days, possibly the I-140 gets approved and then you can port it to a new employer. And the new employer has to file I-485J as per the current rules. We don't know what will come up in the future.
Okay, thank you so much.
You're most welcome.
Hello?
Yes.
Yeah, sorry. My scenario is like initially
No,
I
that's
filed
okay.
in...
I thought the infant also had a question for immigration. So go ahead,
Sorry,
sir.
I
I'm just
joined
kidding.
late.
No worries. Don't worry about it. Go ahead. I was just kidding.
My employer filed EB3 initially and I was in LA. Later, my company got acquired with a company B. I moved to Texas and they filed in EB2. So what is
that
the
was a
best
new
option?
filing. The
Yeah,
Texas
that's
company filed a new. Okay.
Yeah, new perm and a new 140 EB2, and I just did the porting of the initial date to the second one.
You recaptured the prior priority date. Okay.
Yes.
Okay.
So what are my options? Like, can I use that initially approved EB3 or should I file another 40 with the EB3 and 485 together?
Well, you can use the EB3 that was filed and it was acquired by another company. So that is called as a successor of interest. So if they prove that they are the successor of interest and they have taken over not only the company, but also the entire employees and the labor force of the company, they can prove that they become a successor of interest. And in that case, definitely, what is your priority date, by the way?
September 2012.
September 2012. Yeah, so they still do have to notify the USCIS that they are the successor of interest and they've taken over. But you may have an issue because when you did the perm for the EB3, the advertisement and all the recruitment was conducted for LA. It was not conducted for Texas. So the officer adjudicating that may have an issue because the recruitment was not conducted in Texas. And now your company is now moved to Texas. So they may have that issue because realistically speaking, the perm and the recruitment was not done in Texas, it was done in LA. So you may have that difficulty. So my advice to you is to go with the EB2 and downgrade that to an EB3. But if you have the same priority date, I guess you don't even, I guess you'll have to downgrade, because it is May 2011.
So basically what you're suggesting is go for EB2 to EB3 as a new I-140.
As a new I-140, downgrade it to an EB3.
Okay. And along with that, 485, right?
You can file the 485 along with it concurrently, both for yourself and your spouse and any children.
Okay. Yep. Thank you so much.
The reason I
really
say is because it's sticky, because that EB3 was for LA and the perm and everything was, the recruitment was for LA, for California. So you're going to have that difficulty with the US, especially the current administration is not extremely, understanding when it comes to things like that a lot of companies can make moves from one state to another state. They're not going to be very considerate when it comes to that. So you may have problems. And I don't want you to waste your money where there's not much of a guarantee on that issue.
Okay, yeah. Thank you so much. I really appreciate your time.
You're welcome.
Thank you. Yeah.
Thank you, Magaru. Anybody else? Next question. We don't have any in chat, but if you all have any questions, please unmute yourself and speak and ask Magaru.
I can ask a question, Sirishagar. This is Indira.
Yeah, sure.
Hello,
Indira.
Magaru. So recently,
Hi.
there has been a change in the labor laws related to the wages, right? So is there any relationship between those new wages and the current, 485 filing? Will there be an impact?
Not for something that was previously. It's a good question, Indira. There is the DOL prevailing wage rule, which is effective actually from 10/8/2020, but the final rule is going to come out on December the 6th. But they are not going to retroactively apply that to these PERMs and I-140s, which have previously been approved. So they're not going to come and affect those. But if somebody is going to be filing an LCA or a PERM or a prevailing wage determination in the next few days, you're going to be affected by the prevailing wage rule. Having said that, there's already a group of attorneys in Atlanta who are filing a lawsuit in the Washington, D.C. circuit. And there's also some other attorneys from Virginia and Washington who are filing a class action lawsuit against this prevailing wage rule, as well as the expansion of the USCIS on the H-1B rule, which is they're expanding the definition of the specialty occupation. They're redefining employer-employee relationship, how it should be. And the biggest part of it is if somebody is going to be working on an H-1B with a third party, an end client, they're only going to approve those H-1s for 1 year. They're not going to give it. So this is going to be a huge, huge impact on especially a lot of small business owners where, they're going to be affected. And the percentage of increase is so humongous. I don't think many people can afford to be in business paying an H-1B employee somewhere around 140,000 or 150,000 for even a level 1 wage. To be exact, right now the level 1 wage is at 17th percentile. And with this increase, they want to take it up to the 45th percentile. So you can see there's almost like 25% increase. And I don't think many employers are going to be able to handle this. So definitely there's going to be lawsuits, there's going to be injunctions, and the government is going to fight back. So we don't know what will be the final result, but I don't think anything much is going to happen in the next couple of months.
Okay, thanks, Magaru. That helps.
So thanks, Magaru. Any more questions?
Yeah, this is Srinivas. I have one more question here.
Sure.
So my case, EB2 has been filed recently, this last month, and then and the old EB3 priority date is December 2014. So and then my perm is currently valid. It's valid till January 2021. So will there be any difference in terms of amendment or new filing in this case? Which one would be? Because
as I mentioned, I definitely would encourage people to file a new I-140 versus an amendment, because with an amendment, you're going to lose out on the EB2. If you file a new I-140 and your employer is basically reclassifying you from an EB2 to an EB3. So you don't lose out your EB2 filing with that. Has your I-140 already been filed?
Yes, it's already approved.
It's already approved. So now you can file a new I-140 downgrading it from an EB2 to an EB3 with your priority date of December 2014. So under the dates of filing, then you may be entitled to file for the adjustment of status.
Okay, great. So I think in one of the slides, I think you mentioned that if amendment to EB3 is denied, we can need to refile a new EB2 perm and 140.
If you're filing it as an amendment, because by amendment, you're overriding your previous filing. You're telling them in so many words, I'm revoking or I'm amending what I filed previously. I'm taking out the EB2 and putting it as an EB3, which is the reason why then your EB2 is affected. It's no longer existent. So which is the reason why most attorneys in AILA, we've had a recent discussion on this, and most attorneys, even the senior most attorneys who've been practicing for 40, 50 years, all of them have advised that historically, everybody has filed it as a new I-140 as opposed to an amendment. And as I said, even I've done this back in 2012 and 2007, and in 2018 with some of the Chinese people from China. So we had no problems when we filed it as a new I-140. We didn't file it as an amendment.
Okay, great. So if employer agrees, I mean, do they have would they override, go with amendment rather than new petition? Are there any such type of rules? Or if the downgrade
yes, if the employer's attorney for some reason is stuck on it and says, no, I don't want you to file it as a new, I only want to file it as an amendment for whatever reasons, there's nothing much you and I can do, right? We can only request.
Right. So, generally, in case if that option has to go with amendment, as long as it is with the same company and employer supports with all documents, do you see any reason for EB3 downgrade to get rejected or denied?
No, I don't know if it will get denied because still the officer has to adjudicate this application, even as an amendment. So they're going to look at everything. They're going to make sure that you qualify for the position, your employer has the ability to pay, and if this is a bona fide job offer and there is no fraud involved. So they're going to go through the whole thing when they are adjudicating it. So if they have any issues, they may give you an RFE. But the only issue that I feel, if you file it as an amendment, you lose out on the EB2. It is no longer in it. It's gone. It doesn't exist. So if you sometime in the future find that the EB2 line is progressing better than the EB3 line, then coming back to the EB2 is going to be a problem.
Oh, okay. So as long as I do not use the EAD, I can still do interfile to get the EB2.
Not just that. By not using the EAD or any of the benefits. Secondly, if you file it as an amendment, you're going to, the EB2 will no longer exist. It will be gone. Okay.
That's clear. Sure. One last question on the H-1B.
Sure.
So with these new LCA rules in place, how would that impact new H-1B? I mean, if already an LCA is certified, then we have to go with a new LCA, or there is no new LCA required if the LCA is already certified?
If the LCA is already certified, you don't have to go back. As per the DOL prevailing wages that just came out. But if you're filing another LCA to amend something or changing the location, then you're stuck with the new wages. And I believe it's already, if you go to the FLC data center, they've already updated it.
Okay.
But in the next 15 days or 10 days or 15 days, we're all expecting a number of lawsuits against this.
Okay.
And we hope we are successful.
Sure. Thank you so much for all the detailed clarification. Really appreciate it.
You're most welcome. Absolutely, you're welcome. And once again, for those of you who need help, and if your employer's attorney is unable to help you with the downgrade, my firm is open. We are accepting. We're pretty much working every Saturday, Sunday, so that we can meet the deadline of October 29th, which is the last day of filing. So if anybody needs help, please don't hesitate. You can reach out to me. My website is mantralaw.com, which is mantralaw.com. I have over 27, 28 years of experience. Very comfortable working on these downgrades. Like I said, this happened in 2007, then 2012, then 2018. So this is not something new to me. So we've been able to fulfill the needs of people. So if you need any help, please don't hesitate, reach out. And if we think it is necessary, I'm going to request Geeta Garu and the entire team of Sneha Hastam and TCA, if necessary, we will come back to discuss about the H-1B interim regulations and final rules for the H-1B as well as the DOL wage protection rule. So we're going to come back if necessary. If there are no lawsuits, we'll come back and discuss that. I don't know. It'll be up to both the organizations. They have the time.
Subject matter herself is offering the help. So you make the service possible for the community. So definitely.
Absolutely. Thank you so much. But then, you know, all of you ladies are working on a Friday night and really appreciate that.
We appreciate you. You're making community service possible for us. Thank you so much.
We have one question here, Uma Garu. Is there a way to find out what the 95th percentile wage for level 4 for a country is?
We have not yet gotten that information. I know that level 4 has increased from the 67th percentile to the 95th, but I don't have the actual figures on that. And I'm pretty sure it's going to change from state to county to position. You know, it's all going to change. So I don't have the actual figures with me right now.
So, ma'am, I mean, is there a way to make an estimate? Because this foreign labor website gives you the level 4 wage. So do we know, is that a median or is that 67th percentile?
No, they give you actual, you know, the wages per hour and per annum, which is the yearly. They give you both of them on the FLC data center. And I believe they have updated it based on the new rule, which is going with the 45th and 67th, 78th, and 95th percentile.
So what
I haven't seen it, but my understanding is it's already in place.
Right. What they have on their website, is that at what percentile is that? Is that at 95th percentile?
If it is the new one, it is the 95th. That is correct.
Oh, okay. Okay. Yeah, that's kind of my question. Okay. Thank you so much.
Yeah. And I don't know how many small companies are going to be able to afford a 95th percentile.
That's another thing. But I mean, my current application is at wage level 4. I just want to know, because I'm up for a H1 renewal. Like in a couple of days, I will have to apply for it. I'm just curious what I don't want my attorneys to kind of not look at this particular thing and do a wage, level 4 wage kind of a thing.
I am sure they're not going to be able to go around it, because if the FLC data center, if that's what they're using in computing the salary and putting that in the LCA, there's no way to go around that, unless they go get a private survey, which some people do, and that sometimes is questionable. Pretty much, I use the FLC data center, and we pretty much have no problem getting the LCAs approved with that.
Right. I was just looking how much off I'm.
Well, maybe you're up for a promotion. You're going to get a bigger chunk of money.
Yeah, that's wishful thinking, but yeah, I hope so.
I know a lot of Americans who work in big companies, like even Accenture. I believe this is the joke going around that they want to now become H-1Bs because they can get the 95th percentile salary as opposed to what they are getting. So they want to be H-1Bs.
Right. I don't wish H-1B on them.
So, any other questions, please?
No, ma'am. Thank you so much for your service. This has been really, really helpful.
You're most welcome, sir.
Hey, I have a question about the October deadline for submission. So is that the postmark date, or does the actual package have to reach the office, the logbox, before October 29th?
It is, USCIS never goes by postmark. They always go by receiving date. And 30th happens to be a Friday, so you have to send it out by FedEx or any kind of express mail so that it is received by the USCIS by 30th. 31st is Saturday. They don't accept any mail on Saturdays. So your last day is 29th of October.
Okay, thank you.
You're welcome.
Hi, Umagaru. This is Kiran. I have a quick question. Yeah. Hey, good evening, Umagaru.
Good evening.
So let's say like I still have like, this is my scenario. I still have like 2.5 years on my H1. So let's say like I'm actually in process of like downgrading. I'm currently in EB2 right now and in process of downgrading it to EB3. And the employer is filing it as a new I-140.
Okay.
And let's say like maybe like next like a year or a year and a half, like I get my EAD under EB3, correct? So can I mean, like, let's say if I'm not using it, is there a way that I can, like, when EB2 dates come for like EB3 dates retrograde, and then let's say EB2 dates like move forward. So can I, since I'm not using my the EAD which I got under EB3, can I file my new EAD or like 485 using EB2?
Yes, you can. Since you're filing it as a new I-140, your EB2 is unaffected. So you can interfile. And as I mentioned it in the beginning, I'm not sure you were there at that time.
Yeah, I have actually seen it, yes.
Right. You can, there are two ways of doing. Some attorneys have the impression that you can go back and ask for an interfile, meaning using the same 485 and now labeling it as an EB2 as opposed to an EB3, and continue to process that 485. But there are attorneys who say that, no, you cannot do that. You just have to forego and lose out your money on the 485 and refile a 485 under the EB2 category. However, you're not losing your EB2 because you filed a new I-140. You don't lose it. It's unaffected.
Thank you, Umagaru.
And because you've not availed the benefits of the EB3, like you said, if you don't use the work permit and the advance parole, then you can very clearly interfile and jump back into the EB2.
And let's say like once I get my EB3 EAD, like would there be like an employer asking us to move to EB3, use the EAD?
Employer cannot force you to use the EAD. The employer has to continue to keep you on an H1.
Okay.
Okay, if you use the EAD, then your H1 is gone. And once you lose your H1, if for some reason the 485 is denied or something happens, the company goes belly up, then you lose your H1B status, you can't come back.
Right. Thank you, Umagaru.
You're welcome.
One question, Umagaru.
Sure.
So I'm needless to say, I'm on an H1B and my bachelor's is in civil engineering and the new specialty occupation. I had an RFE before. We answered the RFE showing the coursework in math and computers and so on. And I'm up for renewal like in a couple of days, I mean, within the 6-month window. My question is, for this time, I don't have anything. But let's say for next H1B renewal time, let's say if I do a bachelor's in computer science between now and next time, would that help my case for future? Let's say if I do a bachelor in computer science from any university here, there are a few universities which are offering such courses. Would that help? Is kind of my question.
I mean, it all depends what your job duties encompass and what your job title and duties are. Now, if the new H1 rules, which come into place on December 6th, they're amending the definition to state that there must be a direct relationship between the required degree, field, and the duties of the position. If you look at it right now, for example, I can be a mechanical engineer and I can still go work as a SAP. And there are many people who do that, okay? But which is why they are redefining what is a specialty occupation, and they want a direct relationship between the job duties and the education. I can't be a lawyer and go work as a pharmacist.
Right. I think that's where my confusion is, because the job code that I'm in is 15-1132, which is software developer / applications.
Okay.
And if you look at the job description, I don't know how credible the website I just checked is. It says should be having a degree, bachelor's in computer science, mathematics, or one other thing. My bachelor's clearly says it's civil engineering, so it's none of those things. I mean, you just have to go to the coursework and see and match. But if someone in USCIS is doing a match between A to A, apples and apples, this is civil engineering, this is not computer science, and this is software.
Which they will, sometimes they've done it.
What they will not go deeper. That's my concern. So I cannot do anything right now, but for my next renewal, I want to see if I pursue a bachelor's in computer science, would it actually help in my case?
If you are strictly going to remain in the computer science field, yes, you're still going to be doing more of software developing, then yes, definitely it would enhance your chances. And if this rule comes into place, trust me, there's going to be an RFE for every H1, every H1.
Yeah.
Because, you know, you can never have a degree that is exactly matching your job requirements.
Correct.
I mean, I don't think even a president's job, he matches exactly.
That would be a bigger RFP.
Hope one day he gets one like that.
Yeah,
so it was a joke. But if that happens, it's going to be very, very tough.
Okay.
They are changing, you know, they need, for the specialty occupation, they want people to demonstrate the connection between the course of study and the duties and responsibilities of that position. So they're tightening it. They're extremely going to tighten this if this comes into place.
Right. Okay, thank you.
So there's only so much you can be prepared, you know.
Yeah.
Even if President Trump is back, after November 4th, his administration, people can change, people's outlook is going to be different. We may not have Stephen Miller there can be somebody else, or Ken Cuccinelli will be gone, maybe somebody else. So we don't know how this is going to play out. You know? So everything will, you know, revolve after November the 4th. You'll be seeing a lot more changes.
Thank you.
Yeah, can I ask one question?
Absolutely, sir. And could you identify your name?
Yeah, Ankit Patel.
Kemcho.
Bas, majama.
Okay, so, go ahead.
So my mother-in-law put the file for his kids like about 21 in F2 category. F2 category, and the kids was married there, and now file was approved here in USCIS. So the file was automatically canceled. We have to be called the USCIS, or any other category they can change.
They cannot change, sir. Your mother-in-law filed it as a permanent resident, right? For her unmarried children, right? Unmarried children over 21 in the F2B category. Now, if they got married, they are not entitled to get a green card under that category. Your mother-in-law has to become a US citizen and refile the application. They've lost their place in that line.
Oh, okay. That's what I just
Unfortunately, sorry.
Yeah, sorry, but they have no any other way to they change it right now on any other category.
No, unlike the employment based where we can go from 2 to 3, that provision is not there in the family based.
Okay, okay. Thank you, ma'am.
You're welcome.
Good.
Hi, Uma.
Hi.
Hello, my name is Daya, and I have one of my friend. Her name is Parul. We both are nurses. We are working in the Texas right now. We are from Canada.
Okay. Well, first of all, a big salute to you, both Daya and Praful, you said, right? Parul. Big salute to you all because you're the frontline workers, providing so much of support to people under COVID. So I can only say a big salute to you, both of you.
Thank you so much. Thank you, ma'am.
Go ahead. Ask me your question.
Okay, so originally I'm from India. And when I was in India, I cleared all these NCLEX and all these exams. And then I applied for my EB3 category in 2008.
Okay.
And then I just got letter from the immigration that my priority date is current. So I can, I can file, I can send my documents and I can go ahead from whatever I have to do. So
you can file for your adjustment of status.
Yeah, but I applied in 2008. So, but the thing is that time I had a different, the employer. And then now my employer is different. So I talked to my new employer and then they agreed to do my I-140. But they are
because you're a Schedule A, you are a Schedule A occupation. You don't need a perm. You're a nurse.
Oh, we don't need it?
You don't need a perm, ma'am. If you're a nurse, you're a respiratory therapist, a physical therapist, you all come under Schedule A occupations.
Okay, the thing is that then I talked to our hospital immigration lawyer, and she told me that they need that prevailing wage.
You need to do the prevailing wage determination, but you don't do the whole perm. Oh. That's what it is.
Okay, so how long it takes?
Prevailing wage may take 2 months, 4 months. We have no way of telling you the time frame.
Mm-hmm. Because it's since June they applied, but we didn't get any reply. So.
And why are you not going with your first employer who filed for you in 2008? Is that employer not willing to work with you and file the 485 right now?
The thing is that time I was in India, and then it was an agency which I contracted. But the thing is that now I don't have any information about that, the agency, and now I'm working in the hospital. And then, if I go back to the agency, then, I have to do the contract and stuff like that. Right now I'm working in the hospital, so I don't have to do any contract and stuff like that. And then the hospital is willing to do my I-140. So, and I don't have that, the agency information right now. I don't know where they are right now.
Okay.
You can contact me at all.
I don't know. We'll have to, I would suggest if you give me a call or send me an email from my website, which is mantralaw.com. Mm-hmm. Let's see. I don't know if you'll qualify for the 180-day rule under AC 21. If you can do that, then you don't have to refile a PWD and 140. You can just port it to the hospital at that point in time. So that's a little complicated. So what I would suggest is send me an email or give me a call. You have my number in the chat. Pick it up from there, and then we can discuss one-on-one rather than in a group here.
Got you. And the other thing is that after we got our I-140 and stuff like that, how long the entire process takes. Like, I want to know how long it takes.
I'm waiting to get the Aladdin's magic lamp. Once I get it, I will give you an answer.
Yeah, that's true.
Right?
Yeah.
I wish.
Can we have that? Can we have that?
Trust me, if I get it, I'll use it for these priority dates, timelines, for everything, and then I'll give it to you.
Okay, Uma.
I want one Aladdin's magic lamp for our lives, believe me, yes.
I know. But we already got your, you know, the before we joined this one, I think so. Before a week, we had a patient. Then he gave your number, and then he told us to contact you. He's our relatives, and then we were talk about our, you know, the immigration status and stuff like that. And he gave us number, and he told us that you can talk to Uma, and she's very nice. She's gonna help you out. So, and then today we got.
Thank you.
And then today he sent us, you know, the link that
you can join the meeting.
So that's
why. And I'm glad you joined, and thank you so much for joining here.
Yeah, Uma, I have one question. Parul, myself.
Okay. Go ahead, Parul.
Nice to meet you.
Nice to meet you too, ma'am.
You're so pretty.
Okay, so for me, this is the first time my employer is filing I-140 for me. So what kind of process is, and then how long does it take? And
first of all, they have to do the prevailing wage determination, which may take anywhere between 2 to 5 months approximately.
Okay.
Once that is done, then they will file the I-140. You don't have to do a labor certification because you're a nurse. You fall under the Schedule A occupation.
Okay.
So they can very quickly turn around and file it. And once that is approved, and you'll have to wait and see for the priority dates to become current, or if the dates of filing are allowing you to file, then you will be allowed to file the 485 at that time. But we don't know when that is going to happen.
Okay, so 485, I-140, then 485.
Correct. We all go through step 1, step through step 3, but you guys are lucky that you don't have to go through the perm. You just have to go through the prevailing wage determination because you're a Schedule A.
Oh, okay. And then what about the family? For I-140 family?
Whenever the priority dates, meaning the final action dates are current or the dates of filing allow you to file, then your husband and children who are under 21 can apply for the adjustment of status.
But can we, like, we are from Canada, we both are Canadian citizens. So can we have to file here, or we can do in the outside of country too?
We can.
You can do consular processing too.
Okay, does it,
but since you were born in India, you will still come under the line of India. They won't process it as a Canadian. They will process it based on your country of birth.
But we can do outside of the US, right?
That is correct. That's called as a consular processing.
Okay. Well, we're gonna definitely meet you, but we'll call you, you know, the time and date so we can get
send me an email. That is the best way to reach out. That way I can get the email and reach out to you.
Okay, no problem. Thank you so much, Uma.
Thank you.
You're welcome.
Have a wonderful night.
You too.
Thank you so much.
You're welcome. Parul Ben and Daya Ben.
Thank you so much.
You're welcome. Anybody else with any other questions?
Everybody's sleeping. So nobody's asking, so I'm gonna ask you.
Just because nobody is asking, you want to ask, okay.
So let's see. I think so. We apply in June. Maybe you told that it's around 4 months. So maybe in between we are getting, and then my you know, the hospital lawyer told me that they're gonna do my you know, the fast process. What do you call that?
It's called as premium processing.
Yeah, she told me about the premium process, and then after she said that she's gonna help me up to the, you know, getting my I-140. Then I have to hire my own lawyer for the other, you know, the immigration stuff.
Correct. That is for your adjustment of status. That is what most hospitals do for physical therapists or occupational therapists, nurses. This is very typical. The hospital will not get involved in your green card, the last part of your process.
Can you do for us? We're gonna come to you.
Absolutely. Absolutely.
Okay. Okay.
Okay. મને ગુજરાતી બી આવડે છે.
ઓકે, તો બહુ સરસ.
તો આપણે ગુજરાતીમાં જ વાતો કરીશું.
તો બહુ સારું અમારા માટે.
Contact me, send me an email, ladies. I'll be glad to.
Sure.
Thank you.
Thank you so much.
You're welcome. Anybody else with any other questions?
Someone is
Garu, I see Sandeep Garu has joined. I don't know if it was call fallout and call back in. We'll let him ask the question just in case he has any.
Sure.
Last minute join. So.
It's Friday night. Everybody's got their own activities, you know.
Yeah, absolutely. Thank you so much for staying longer to answer the question.
No problem.
Please unmute yourself, Andy, to ask the question. Sandeep Garu.
Yeah, thanks, Sandeep. Hello, Madam. This is Sandeep from Pittsburgh.
Yeah, hi, Sandeep.
So, quick question, Andy. So, basically, my company is actually asking me to downgrade to EB3 to get to file I-1 for 485 and get the EAD quicker. I just want to ask, is this a good idea to downgrade right now and get that EAD, or should I not do it?
I know you missed the entire webinar where I was talking about what are the advantages, disadvantages of downgrade and also amendment versus new filing.
Yep.
Let me say something, Sandeep. You know, I have been practicing law for the last 28, 29 years. In all these years, I've seen the visa bulletins when they became, the final action dates became current. Only a few times, I would say 96, 97, then 2000, 2012, and 2018. So we don't see this happening way too often. So if there is a way for you to get your EAD and advance parole faster, then this is your one chance. Okay. I'm not saying do it because your employer is saying, but I'm saying because possibly we've been noticing the EB3 category has definitely been moving better than the EB2 category in the last 6 to 8 months at least, based on the visa bulletins. And also Mr. Charles Oppenheimer, who is the one who talks about the visa bulletin and predictions, he's also said that he definitely thinks that the EB3 would move better than the EB2. So based on that, yes. What is your priority date?
It's 2014 June.
June 2014. So if you downgrade it to an EB3, yeah, you would be entitled to file under the dates of filing. Now, come November, we will have the bulletin. Maybe they'll release it by next week or the end of the month like they did for the October bulletin. But we are not sure if the USCIS will say that they're going to accept applications based on the date of filing. And if you look at the final action dates, a lot of people are not going to qualify.
Okay. And is there any reason why I should do a premium filing, or can I just do normal processing?
You cannot do a premium filing when you're downgrading your EB2 to an EB3. The reason being your perm was already used, the original perm, certified perm, was used with your I-140 when they filed it under the EB2 category. So this time you would be downgrading and using a copy of your perm. So whenever the USCIS gets a copy, typically, historically, they've never allowed people to file under premium processing. So what you would have to do is file it as a regular and give them a month or two because they go and pull out the original perm from your EB2 file. And it's going to take maybe at least 2 months, if not longer. And then you could subsequently file it as a premium processing.
Okay, thanks, Andy.
So once that I-140 is approved under the EB3, and then your 485 is adjudicated towards receiving your EAD and your advance parole as a combo card, if you determine that you will remain in this EB3 category, you don't want to jump back into the EB2, then and then only I will use the EAD and the advance parole. But if you feel like I want to be a cat on the wall, I want to see if EB3 moves faster or EB2 moves faster, and I want to take advantage of EB2 is moving faster, then I would not use the EAD and the advance parole. But you would file it because in case you have to leave the country, travel out and come back, and you can come back on your H-1B stamping, but you still need to have an advance parole. If you don't, they will consider that you've abandoned your I-485.
Okay, yeah, thanks, and that's all I have.
Sure. Any other questions?
Umagar, I have one more question.
Sure.
So my priority date is 17th February 2016. And
would you repeat that?
16th February 2016 is my priority date. It is EB2.
2016?
2016.
Okay.
So right now the EB2 date is around 1 Jan 2015, and there are projections and rumors.
That's EB3. That's EB3.
You're right, EB3.
Yeah.
So what my company has done is this month they have filed for EB3 downgrade for around 50 of EB2 folks. Right. I don't know what they are doing, whether it's they said something about AOS, adjustment of status. So I don't know if that's with new I-140 or not. So what they are doing is they're waiting for the November bulletin. I asked for them to do a voting, and they wanted me to wait for the November bulletin, and then they will take an action. So if they are doing it, what are the things that I have to be careful about in terms of how they're applying, so that I don't lose some of these privileges if it retrogresses?
We don't know what will happen with the retrogression and as far as benefits. Now, if you are filing under the EB3, but you said your date is 2016. Yeah, so I'm looking at the dates of filing for EB3, and you're from India.
Yeah.
Right? Even with the dates of filing, it is showing Jan 1st, 2015. So you will not be able to file the adjustment of status under the October bulletin.
Not October, but they are expecting November bulletin to go at least 1 year. There are projections, but if it comes to that, let's say if the November bulletin says that date is March 1st, 2016, what should be my...
Then you can file for the, and if they are, even if the bulletin is, let's say March or April of 2016, let's say it advances. That doesn't mean you can automatically file. The USCIS has to come and tell the public that they are accepting applications under the date of filing.
Okay.
If they say we are going with the final action dates, you won't be entitled.
Got it. Okay. If they do that, then you would advise to go ahead and file for EB3 and go with the process.
Right. I mean, that's what they are going to be doing. You said they are downgrading you and bringing you from the EB3 to the EB3 line. With the hope that the November bulletin advances, with the second hope that the USCIS is accepting the dates of filing.
Got it.
Okay. Now I want you to do me a favor. Go to that attorney. If he's got a lamp or a parrot, I want that.
No, it's not the attorney who is doing that. So there are a lot of people who say that this will go further. I'm just weighing all my options. If it happens,
no, I'm just kidding. I'm just kidding.
My attorney is not even in communication with
oh wow,
because they are focusing on the October folks. November is too far for them.
Okay, got it.
Thank you.
Wish you all the best. I hope it works out.
Sure. Yeah. Thank you so much.
And anybody needs any help, and if your employer's attorneys are too busy, like we said, we are taking up cases. If you all need help on the adjustment of status, we're glad to do that for you. Please reach out to the team at Mantra Law Office. Just go to mantralaw.com. It's very simple. And please send me an email. We'll be glad to help you. Sirisha Garu and Geeta Garu, I guess we've come to the end of this session for today.
Yes, Magar, looks like everybody got a fair chance today. We couldn't cover the questions last time, right? A few missed out last time.
There were way too many last time.
Yeah, and this session is being recorded and it will be posted on all the channels, like the last session. In case anybody missed some information, they can leverage the video. Thank you so much for doing this, Uma Garu. Thank you for again taking up the follow-up call. As you said, the topics that you addressed, probably we can do another session next month or so.
Yes, if the necessity comes up, I will definitely reach out to you all, and I'm sure the community looks forward to this kind of webinars where, sitting in the comfort of their home, they can at least get some clarifications. If it's not 100%, at least 95%.
Absolutely. Thank you so much again. Kudos
to you. Thank you so much, Uma Garu. Indira Garu, do you have anything?
Yeah, no, I just wanted to thank as well from my system as well. Thanks a lot, Uma Garu, for spending time on your Friday evening.
My pleasure.
Answering several questions. Yeah, thank you.
Appreciate it. And thank you, ladies. And thank you, everyone. Have a good night.
Yeah, good night. Thank you all for joining. Thank you.